every pre-1933 blue sky law required that there be post-sale obligations on the promoter of the alleged security. Looking at page 19 of the brief, quote, "There also can be no investment contract unless the contract includes an undertaking of post-sale obligations by the promoter to the investor. Otherwise, the contract is simply an asset sale. The blue sky cases rejected attempts to fit contracts without such obligations into that statutory language." So what's that mean? That means that when Ripple sold or sells XRP to you, it must have a legal obligation to you of some sort in order for there to be an investment contract and for there to be a sale of security. Let that sink in for a second. In other words, when you bought XRP, Ripple must have had a legal obligation to do something for you. But think about it. If Ripple decides to drop XRP altogether and use XLM instead for cross-border payments, do you have any legal recourse? No, you don't. There would be nothing you or I could do about it. Ripple has no legal obligation to you, and that, my friends, according to blue sky laws, which interpret the US securities laws, is the sale of an asset and not of a security.
A security is something that represents ownership in a company. It gives you rights to dividends, give you rights to governance, things like that. The amount of misinformation on this one, I think, is also profound. If Ripple, the company, shut down tomorrow, the XRP ledger would continue to operate. So if XRP is a security, it's a security of what? XRP is not a security, and I think that, you know, as time goes by, that'll become clearer. So I don't spend a lot of time worrying about that.
You seem pretty relaxed about it.
I actually am pretty relaxed about it, because I think the facts are on our side.